I teach this stuff at the CU Law School. Don't make this like my law school class where everyone is asleep by the end. Ask questions, participate. I want you guys to get out of today whatever you want to get out of it. Basically, I have stuff that I'm prepared to talk about, but if you don't want to hear any of it, what's the point? So I want you guys to interrupt me, throw stuff at me. I'm a lawyer, I'm used to getting hit with things. Just make sure if you have a question, you're not sitting on it, because other people probably have the same question. There are no stupid questions. We promise not to make fun of you today, at least to your face. Holly and I will do that later. But no, there really are no stupid questions in estate planning. It's a really complex area of law that almost no one knows anything about. So we're here to educate everybody. In order to encourage participation, I give away prizes. It's the coolest prize in the world. It's a book. You're welcome. I hope people love reading so much. But we published a book, somehow hit the bestsellers list because people like to torture themselves, I guess. But we do a presentation series. So this is the second of 3. If you didn't go to the first one, that's fine. It's not like we can cover everything. But the book basically summarizes all 3 of the presentations. So our whole series is a breakdown of this book. If you answer my questions correctly, you get a copy of the book. I know, super. And then last but not least, what did I say? Interrupt me, ask questions. Oh, what do you guys want to know about today? So think in your mind, like if this was a 10 out of 10 presentation, it's the best one you've ever been to, I know. What would we talk about today? What would you learn? So I'll jot some things down, but just throw them at me. What do you guys want to know about today? The plan is to talk about Medicaid and estate planning, but yeah. Oh, definitely. Yeah, co-executors. We'll talk about that. I don't recommend it, is the short answer, but we'll cover it a little bit more. Yeah. Create and amend a trust. Yeah, and maintain a trust for sure. What else? Yeah. There's no stupid questions. Bring them on. Yeah. Yeah, fees. That's a great thing. We'll talk about fees in general. We'll talk about our specific fees and what to look for in other attorneys and stuff. So yeah, we'll cover that. How long is the whole process? Just, okay, yeah, estate planning, and I'll talk about probate a little bit too, because I'm assuming both would be helpful for you. Good questions. Those are great questions. Yes, ma'am. So put a property transferred through a will or transfer it into a trust to be distributed. Yeah, will or trust. That gets into a broader one of just will versus trust, but we'll do that too. What else? Yeah. When is probate necessary? Perfect. Yeah, we'll talk about all that. I like it. We got one on this side of the room. Thank you. We'll talk about it for sure. Yeah, that's the most common question I get. What is probate, and then what is the difference between a will and a trust? So we'll address all that. So today is normally focused a little bit more on special needs planning and Medicaid, but I'll still touch on that. Is anyone here specifically to find out about Medicaid and special needs planning? Okay, I'll talk about it less. Great. You know what? We just roll with the punches. So we'll focus more on wills, trusts, probate. What is all that mumbo jumbo? How do you get through it? How do you avoid it? That's a good one. How long is the process? How much does stuff cost? What else do you guys want to know? Anyone want to talk about taxes? I could talk about taxes all day. No? No takers? It's like math. No one wants to talk about it. Death and taxes. There you go. Great question. I'll talk about taxes. It's her fault. All right. Well, if you think of anything else, just let me know. You're trapped in the room for an hour with a lawyer, so I apologize in advance. Wills, trust, and Medicaid, oh my. So I guess a little background on me before we dive in. We work just down the street, like 2 minutes away from here in North Glen. We do estate planning and probate, and that is all our lawyers do. There's about 12 people in the firm, 8 lawyers, and we all do the exact same thing. This is all we do. I teach this at CU. I wrote a book on it. I'm kind of obsessed with this topic, so I apologize in advance, but there's a lot of info to know, and we're going to get through as much as we can. But starting off, I think a good base is what the heck is estate planning in the first place? So no cheaters. Go away. Thank you. What's estate planning? This is my first chance to win a book, guys. Yeah, that's pretty good. Anything else? I like both of those answers. I love how I make the slide go away and you all have the slides right in front of you. Here you go. First 2 books. Congratulations, guys. All right, so those were good. I like to say it's any set of documents that helps you protect your stuff, your family, and yourself, both while you're here and after we pass away. So that's a huge category of documents. I like to narrow it down and say there's really 2 routes that we can take. There's a will-based plan and there's a trust-based plan. And we're going to get into what each of those plans looks like and what that entails. But really, the overall gist is you get to leave a legacy. You get to leave things to the people you love and care for, or the organizations that are important to you, anything that's close to your heart. You get to stop fights. So one of the missions and reasons we started this law firm is to keep families together. We always say there's a lot to look forward to with estate planning and probate. There's not a lot to look forward to in probate. There's a lot to look forward to with family, and we don't want estate planning and probate to get in the way of that. And unfortunately, it does a lot of the times because people either don't do it or they have a plan that's not set up to achieve their goals. All kinds of things can go wrong. So you get to leave a legacy and you get to stop fights. And then ultimately, you get to say where things go instead of the state. So show of hands here. Let's see how many people are going to lie to me today. Who here has an estate plan? Any document, will, trust, powers of attorney. Okay, we've got some honest people in here. People that didn't raise your hands, thank you. Usually everyone's like, oh yeah, I don't want to be the one that doesn't have an estate plan. Over half of people in the world or in the United States don't have an estate plan. And that can be really sad when you get to see the other side of how that impacts families and how it can tear people apart if there's an argument over what mom wanted with the wedding ring or what's supposed to be done with the house. Someone wants to live there and the rest of the kids want to sell it. So the lack of estate planning is pretty prevalent and it's a bummer. But I guess the good news that the state would say is don't worry, all of you who didn't raise your hands, the state has already written a plan for you. So congrats. And guess who's a beneficiary in that plan? The state. Yeah. So there's a chance in your plan that you don't know that you have, that Colorado could come in and take all of your stuff. It's a far off chance, but there's a chance. If you do your own plan, you get to decide where everything goes. And you don't have to worry about what's the state going to say happens with my stuff. And a lot of the documents we talk about today, the state has defaults for all of them if you don't have one made. And we'll kind of talk about what that means a little bit more. All right. Questions so far? No one's throwing anything at me yet. All right. Oh, I also have a 2- and a 4-year-old, so you have to put up with my dad jokes throughout this. But Mr. Frosty, it's March, time to talk estate planning. Unfortunately, this is when most people come to talk about estate planning. It's when it's almost too late, or it is too late. It can be too late to put an estate plan together. I've had people call and say, hey, mom's in a coma, can you come to the hospital and we'll just put a pen in her hand. We have all the documents ready to go. We just need a lawyer to confirm that everything's okay. I'm like, well, I can tell you right now, nothing is okay about anything that you just said. Once you don't have capacity, you can't sign documents anymore. And people usually can't sign them on your behalf. So it's definitely can be too late to do an estate plan. A fun fact or statistic I saw the other day was, I'll just ask you guys, and then I'll tell you what the stat was. How old do you think you need to be to start thinking about putting a will together, or to actually do it and put it together? That's a good answer. All right, you guys are all smart. So statistically, most people say that you need to be 80 to really actually think about doing a will. You guys know what the life expectancy is? Like 76. So people think you need to wait until you're dead to do your estate plan. Go figure. And unfortunately, that's what happens. People just keep putting it off. They're like, well, I don't need that yet. I don't have enough assets. I don't, whatever excuse you want to fill in there. And you were right on the head with 18. We do estate plans for 18-year-olds at our office because the parents come in and get their estate plan put together and their kid's going off to college. And what parents don't realize is that they now have lost all control over that child for many reasons. But once they're 18, they're still parents, but they don't have any of that control that they had when their kid was 17. So their kid gets in a car accident at college and they're trying to call to see where the ambulance took them. They won't tell them. So they don't know where their kid went. They need to access a bank account. They can't because it's their kid's bank account, not theirs. Powers of attorney, which we'll talk about today, are super helpful for anyone, no matter how old. Well, you have to be over 18, but younger people too. But in estate planning in general, my answer is usually when people are like, when do I need to put an estate plan together? My answer is usually yesterday. All right, so 4 documents everyone should have. If you wanted to be surprised today about what we were going to talk about, close your eyes and don't listen to me. These are the 4 documents that really everyone should have. You got your will, your 2 powers of attorney, so medical and financial, and then the living will. And we're going to go, I always do the bonus document of the trust. It's not included in one that everyone should have because there are situations where maybe you don't need a trust. And trusts are really helpful and they're awesome documents. I have one, but not everyone needs one. You know, if you don't need it, don't buy it. But we'll talk about it. And then all of these are talked about in way more detail in the prior presentation that I have done here, which is the You Only Die Once presentation, do it right the first time. It's also the name of the book. I'm kind of sarcastic, I'm sorry. All right, so I'll do a quick summary of these up here because we're gonna go through them all, but the living will I'm gonna focus on a little bit more right now because I don't have a specific slide in this deck for it. But who has a guess on what a will is? So who you want in charge, and where you want your stuff to go, when? On your death. That is exactly right. You raised your hand. I'm sure you were going to say that. So there you go. I love it. So a will is just a stack of papers, says where you want your stuff to go when you pass away. You name who's in charge of the show. What's that show called? Probate. So the process that your will is basically controlling is probate. So you guys had asked in the beginning, what the heck is probate? Probate's just court after we pass away. Congratulations, we're all designed to go through probate, whether we like it or not. But the light at the end of the tunnel is estate planning lets you decide if you want to avoid probate or not. So you can put a plan in place that avoids court. But if you don't do that, enjoy probate in most cases. We'll talk a little bit more about that. But yeah, so the will, just the instruction sheet for that court process, says who's in charge, where your stuff's gonna go. A really key aspect of a will is a guardianship, but I'm getting ahead of myself now. Who knows what either power of attorney are for? To do what? To who? when. It's a very specific time that their power kicks in. Bingo. So that was all my books. Sorry, guys, you win. The powers of attorney kick in to help protect you while you're still alive, but incapacitated is the key word that I was going for. You can draft powers of attorney to be effective immediately, but most, a vast majority, are drafted to only kick in once you lose the ability to act for yourself. So Alzheimer's, dementia, car accident, coma, anything like that. And then the living will. Anyone know what a living will is? I found more books. Yeah, that's 100% right. So Dolores is 100% right. A living will. This is the document where people morbidly call it the pull the plug document, but it's where you get to decide if two doctors come in, and I'll pick on Holly, because why not? And they say, Holly has no more brain capacity. She doesn't know she's alive anymore, and she will never know that again. But life support is keeping her going. How long does Holly want to stay on that life support? I have a lot of questions on this one, but I'll spare you. I have a lot of stories on it too, but that is just a very, very, very stressful decision to leave to your family. It's one where when this document doesn't exist, I've seen the most and the worst fights. This is where the word murder gets thrown around, and that's not fun at Thanksgiving dinner. So the living will lets you decide how you want to be treated in that end-of-life situation, and it takes that really stressful decision out of everybody else's hands, and they don't have to stress about it. Because even if no one's fighting, I've seen many, many people have to make this decision in my family too, and they second-guess themselves the rest of their life if there was no document there saying, this is exactly what I want. Yeah. It is similar. I'm glad you asked that because I'm not a huge fan of the 5 wishes document. It's better than nothing. If you have nothing, go get the 5 wishes document. If you have a plan and then you do a 5 wishes document, that 5 wishes document oftentimes from what we see contradicts the old plan, and then there's fighting about which one is supposed to be the accurate one. And usually just the newer one wins. But a lot of people don't even realize they're contradicting their old plan. And a full plan should address everything that the 5 wishes document addresses anyway. For those of you that don't know, the 5 wishes document is a great, if you have nothing, it is a great document. And the person that made it had a great reason for making it. It's just a stack of some, mostly medical, estate planning documents that you can basically, it's a do-it-yourself. And you can fill in who you want making medical decisions for you, how long you'd want life support, do you want a DNR, all that kind of stuff. And the reason was this person saw what we see every single day in her family of when someone passes or is in the hospital and doesn't have anything in place, and how terrible that can be for the family. So she basically made this free resource and put it online and got it out there, and it exploded, which is awesome. But people with estate plans started messing up their plans because they would fill out the 5 wishes document on top of their plan, and they would contradict each other. So just don't do that. So if you have a plan and then you override that plan with something else, depending on what's overridden, that's a very fact-specific question, but depending on what's overridden, you would need to redo and then throw everything else out so there's no confusion. I don't like finding multiple estate plans when people pass away. The law says like what order things are supposed to go in. The newest one usually wins. If it doesn't contradict, then you try to read both of them together. And it can just be kind of a nightmare. And I'd just love to see one concise plan that says everything that's supposed to happen and who's in charge. And you get less fights with the bank and the doctors, and the family's happier that way. Ideally. So in Colorado, The living will and the will have to be 2 witnesses. I recommend 2 witnesses and a notary. The statute technically says or, so you could do 2 witnesses or a notary. We always do both. Financial and medical powers of attorney only have to be notarized, but some states are different. So it's never a bad idea to do all of it for all of them, but you don't have to for some. You actually can't have this is where a lot of people screw up their plans. A lot of people like online plans, a lot of people like do-it-yourself plans, and this is one of the biggest mistakes that people make is they have the people in their house just witness or notarize or whatever. You can't do that. The witnesses have to be disinterested, meaning you shouldn't be related to them. They can't be listed in your will. So the problem you have is actually a good one because it forces you to get correct witnesses. Hey, you're welcome. That's what I'm here for. Yeah. Yeah, for the love of God, give them everything. There was a big trend, a decade or 2 ago where, don't tell anyone what the will says. Keep it secret, put it in the safe deposit box, and no one should ever know because they're going to steal everything you have. Tell everyone, post it out in your front yard. I don't care. What are they going to do with your estate plan? It doesn't say how much money you have or what your bank accounts are. It just says who's in charge and where you want things to go. And the more, bless you, the more people that know that, the less people can fight about it. So I actually have a whole family meeting at the end of our entire process where I tell you, bring the whole family in because we're going to tell them everything. They're going to inherit 75 cents and it's split 4 ways, so enjoy that. But mostly not how much is there, but how is the distribution of whatever is left supposed to go. And this is really important. It's really important in every family, but it's very important for blended families, and especially when you're treating people differently. And a lot of people get very, anxious when they think, well, I'm leaving Johnny 10% less than Susie. I don't want him to know that. Johnny better know that before you die because he can't ask you when you're 6 feet under. So then Johnny's going to fight Susie and say that Susie influenced you to do that will and had a gun to your head. And if you're not there to say, look, Johnny, you make 10 times more than Susie, so I'm leaving you 10% less, get over it. He's going to fight about it. It happens almost every time. So have the conversations. I say the conversations behind the documents are just as important as the documents themselves. So let's get into what these documents actually are. What the heck is a will? We already talked about that. It's getting things where you want them to go, and saying who you want in charge. Now, we didn't talk much about probate. I know we had questions on probate, so I'll answer them here. You had questions about co-executors, right? In the back, I think somebody did co-executors. So we'll talk about that right now. Will, just an instruction sheet to get through the probate process. So a lot of people think I have a will, I get to avoid court, I've already said everything that's supposed to happen. Great, my family's taken care of. That's a lie. If all you have is a will, you're guaranteeing your family's going to probate because the will is just the instruction sheet for the probate and you're naming the personal representative. Anyone heard the term executor or executrix before? Lawyers just like to confuse people. It's the exact same thing. If you hear me say any of those terms, it's just the person that's running the probate process. And they have 4 main duties. They have to find all your assets, value all your assets, pay any creditors, and then distribute everything per the terms of your will. Once they do that, probate's over. Pretty easy, right? No. So probate in Colorado is a minimum of 6 months long. I should say that most states say that we are the quickest, easiest, cheapest probate to go through in the nation. I don't think 6 months is very quick, but other states take years. I've seen probates in Colorado take years too. Just because the minimum is 6 months doesn't mean it's going to be done in 6 months. Low cost. So average probate, you could expect to spend between $5,000 and $10,000 on a probate, maybe more. We do uncontested probates, and our average is right around there or higher. So no one's fighting. We're just trying to get through the 6-month process. So I don't think that's cheap. And we're the lowest cost probate in the United States. And then, so quick, easy? No. No one's enjoying going to court and saying that was an easy process. So Avoiding probate is usually our recommendation. If you can, why not? You avoid that expense, you avoid that stress on your family, and I mean, who wants to deal with lawyers more than they have to? Probate's optional. What do you mean? You do. The dead person. So basically, every expense, creditor that's paid, legal fees, court costs, people that have to clean up the house to sell it and then sell it, all those expenses come out of your bank account, the dead person. Sorry, you're dead now. Yeah, if you avoid probate, then normally we're just distributing things. Debt goes with stuff. So, you know, the mortgage on the house, I can't get rid of that for you. You know, we'd be making way more money if we could do that. But debt follows the assets. One big thing, though, is I said pay creditors is one of the roles of the personal representative. If you're ever in this role, don't just immediately start paying all the creditors that show up, because some of them are scams, some of them are invalid claims, and creditors know that there is a court process they have to go through to get paid once a probate is open. And if they don't do that process, we don't pay them. And they have a certain time limit to submit their claims properly. And I had, there was a bank that submitted a claim a day after their period. They have 4 months, and they submitted their claim 4 months and 1 day after the person had, after we'd opened a probate, essentially. And they had tried to change the date on the letter to make it look like they had sent it earlier, but I could see the postmark date, so I knew when they sent it. So I denied their claim and told the judge what they were doing. And it was a $40,000 claim, and we paid zero of it. So that's something we take pride in, is we usually try to say that, you know, you hire us because we pay for ourselves. I mean, we saved that family $40,000 on one creditor. Most times people just get creditor claims and just start paying them, and they'll pay them out of their own pocket. If there's not enough in the estate, if Dolores passes away and you've bounced your last check because you were having a great time and partying your whole life, I told you I was going to pick on you today. No creditor gets paid because there's no assets in the estate. I don't care if her kids are billionaires. Your estate is what is responsible for your debts. Now that changes if you have joint debt, so you have a credit card in both of your guys' names or anything like that, the joint owner's on the hook for that. But otherwise, I die and no joint debt, I could have $1 million in debt. If I don't have any assets, no one pays that. That's all just gone. Make sense? All right. So, with all that, who can tell me what probate is now? Bingo. After you're dead, hopefully. Yeah. So all the legal mumbo jumbo I just said, you said 100 times better in one sentence. It's just the court process after we pass away to transfer assets. So the other thing you can do in a will is, to me, the most important thing. If there are minor children involved, you can name a guardian. And a guardian is just who's mom and dad if mom and dad aren't there anymore. And that is one of the only, if not the only, ways to avoid foster care in Colorado. I like to let that one sink in a little bit, because this is why it's so important for younger families to have an estate plan. Because I can't tell you how many times we've seen mom or dad pass, and then the child ends up with someone mom and dad would not have wanted that child to end up with. I have tons of horror stories on that I will spare you from. But just having a guardian in place, we see grandparents fight about this a lot, where children pass and the grandparents are like, well, my son told me we would be the guardians. And the other set is saying, well, my daughter told me we would be the guardians. And then they're in court tearing this kid's life apart, arguing and screaming in front of a judge, and the kid has to be there. So the will just stops all that from happening. Key point there, guardianship does not stop the guardianship hearing. So the court cares too much about minors. Even if you say who's in charge in a will, if there's an 8-year-old and they need a parent, you're going to court, because the judge wants a credit check, a background check. They want to make sure whoever's getting the kid isn't a felon or has done terrible things. They want to make sure that best interests of that child are protected. This is also really important. I said we'd talk about Medicaid and special needs. This is also really important if there's anyone that you want to inherit, whether they're related to you or not, that has a special need. So autism, Down syndrome, there's a whole list in the Medicaid statutes of what qualifies. But usually if someone's on Medicaid and has qualified because of a special need, you can name who you'd want to be the guardian of that person if you're the current acting guardian. And that's really important too, because if you're gone, there's usually no one left to care for that person. And we see that a lot with parents with special needs children who've been living with them their whole life and their kids are 60 and then they pass. And there's just, that child doesn't know how to support themselves and there's no one left to care for them. So this sets that child up for the rest of their life. All right, that's wills. Fun fact. This is the most worthless document that we do for people. That's fun to hear from a lawyer who drafts wills for a living. That doesn't mean they're not important. All estate planning documents are important. The will is just on the bottom of the barrel. That's because if we're using your will, we're in exactly. We don't want to be in probate. All our plans, my main goal for my clients is basically, let's keep you out of court, out of probate. So if I succeed at my job, we never use your will, ever, because we're not going to court. Does that make sense? It's nice to have as a backup because if we end up in court, it's nice to know who you want in charge and where you want things to go. So, powers of attorney. We already talked about this. Lets you name people to be in charge of your stuff while you're alive if you're incapacitated. So guess what the medical power of attorney is doing? For not any medical or legal, just the medical stuff. So talking to the doctors, okaying long-term care, hospice, surgeries, any medical decision, that's your medical power of attorney. So kind of implied in the name, what do you think the financial power of attorney is doing? Yeah, exactly. Yeah. Great question. You have to come to all my presentations now. So no, the question was, can you only have one medical power of attorney and one financial power of attorney? So in a way, yes, mostly no. I like people to name one person at a time. So Holly is my #1 financial power of attorney, and then Steve is the backup to Holly, and then Dale is the backup to the backup. That way, if Holly dies, I kill Holly off all the time, sorry Holly. If Holly dies, Steve's there, and we don't have to go to court to get a guardian and conservator appointed for me. So one after the other, we like 3, so you have your primary, your backup, and your backup to your backup. However, don't name 3 people at once, and don't name 2 people at once. So don't have Holly and Steve together as your agent. I say that. People start freaking out when I say that. You can do it. It's legal. I just, from experience, think it's a terrible idea. The point of these documents is to stop what we call a guardianship and conservatorship hearing for you guys. So incapacitated adults and minor children are treated exactly the same under the law when it comes to this stuff. The court just comes in and says, neither of you can make your own decisions. We have to appoint someone to act for you. And when you come in with powers of attorney, you're saying, I don't want that court hearing. I've already named my people. So powers of attorney stop that entire court hearing from happening. Why I say don't name 2 people is because if they ever disagree on anything, there's no third-party tiebreaker. So whoever phone is going off, you have to dance to the ringtone. That's what the judge used to make us do in court. How ridiculous is that? But if there's a fight, then we're in court, even if you have an estate plan and financial or medical powers of attorney. So one at a time just stops that from even being a problem. They can all still work together. It's just you have that final decision maker if there is a disagreement. Does that make sense? Yeah, so if your agent can't make decisions for you, it automatically, our documents anyway, and that's how most of them should be written, it automatically goes to the second person. They would have to... If they can't do it for whatever reason, the second person just has to prove it. And that can be from a letter from that person. It could be a death certificate. It could be a doctor's letter saying they've lost their marbles, whatever. Yeah, don't do that though. Because then it's real confusing. Banks are the ones, sorry banks, banks are the ones that cause a lot of problems here. If you say and or, the bank doesn't know who they're supposed to listen to. And a lot of times you're like, well, that's obvious, either of them, I don't care. Banks are very, very particular and anal about how much money or any money that they're releasing to not you. For good reason, I give banks a hard time, but we've had to go after banks. When I used to work at the public administrator's office, we have to go after them all the time for giving money to the wrong person. So someone presents a power of attorney, but it's 15 years old, and there's actually a new power of attorney, and that one's not even valid anymore, but the bank doesn't know that. If they give money to that person, that money's gone, and the bank just has to produce that money and put it back in the account. Nope, which is weird. You'd think they would. So the court used to accept wills. I used to work over in Adams County, the public administrator's office. Has anyone ever heard of the public administrator's office? Hopefully no. Sorry that you said yes. Usually things have gone horribly wrong if you're at the public administrator's office. So I worked for the deputy public administrator in Adams County, which just basically meant whenever the worst of the worst was going on, they would appoint our office to kind of come in and clean up the mess. And we would see a lot of times where co-agents would be ruining things when they said and or, and they weren't sure who to work with. It's just not a, just from experience, it's not a great thing to do. It eliminates all of these problems if it's just person A, then person B, then person C. Correct. But it's your decision, not B's. So B can deal with it.
You're still the boss.
Yeah. Yeah. Yeah, thanks for pulling me back around. That's what I was talking about. So the courts don't accept them anymore. You can't file them in advance, and the banks don't know. So that's the hard part. There is no central, I have to be careful when I say this, repository, not suppository. There's no central repository of estate planning documents. So banks can't check. They're just trusting you. So if you come in with a power of attorney and it's kind of old, they will just deny it. And we see that all the time. So if it's one of our clients, there's a law that we can use to write a letter to the bank saying, we're enacting this law. You have 5 days to listen to this power of attorney because we swear under oath that this is the only power of attorney. And then if you're lying now, that's a felony, and that's not good for the person with the power of attorney. So the bank usually pushes back, and then the person comes back with that letter and the power of attorney document and more proof. Banks change their mind on that. I would say 10 years is definitely considered old by banks, but documents don't go stale. So they could be 30 years old if it's still what you want and it's signed, witness, notarized. I mean, it's a valid plan. And there's just maybe some extra pushing that has to happen for the banks to get them to listen to it. Yeah. Trust next. It's this slide that I want. So that is when we get kicked into guardianship and conservatorship hearings. So what the bank will say is basically you need a court order telling us we have to do this. And hopefully then they will go talk to an attorney. And hopefully that attorney then knows to try all the other steps first, because guardianship and conservatorship is what, I mean right here, stop guardianship and conservatorship hearings. That's the whole point of powers of attorney. So those should be a last resort. But I mean, I've seen those go $5,000 to $10,000 each. Guardianship is if you don't have a medical power of attorney, the court comes in and appoints one for you. Conservatorship is you don't have a financial power of attorney, the court comes in and appoints one for you. Then you get the joy of spending $5,000 and $10,000 or more to a judge and the courts and attorneys, and then you get the joy of that judge who you've never met appointing a stranger to manage all your affairs for you, and then you get to pay them like $200 or $300 an hour. I don't know anyone that thinks any of that sounds fun. Powers of attorney stop all of that from happening. And this is really important to pull the focus back to special needs a little bit. For Medicaid, especially for people with special needs, if they still have capacity, which most of them do, can draft their own medical and financial powers of attorney to get helpers to help them in situations where they may need it. And that stops a court hearing for them too. Yeah. Yes. Yes, is the short answer. So the question is, can my power of attorney be put on a signature card at my bank? Yes. There are 3 ways to be on a bank account. You can be an owner, you can be a signer, which is what you just said, and you can be a POD, payable on death. And this is, everyone wake up, because this is the most important thing that I'll say today, I promise. Beneficiary designations are the most important things you can have in your estate plan. It's the most important estate planning tool that we have in our toolbox. And the fun part is attorneys can't do anything about it. You guys have to do your beneficiary designations. So does anyone know what a beneficiary designation is? Yeah. That was perfect. I don't know if I can give you another book. So yeah, a beneficiary designation, couldn't have said it better. But if you didn't hear her, it's just allowing you to name someone to get or inherit your asset when you die. So bank accounts are a big one. The bank calls them PODs, payable on death designations. That's what I recommend to answer your question, why I started rambling about this. I would rather see you just have a financial power of attorney because they already have access to your bank account, and then put them as a payable on death beneficiary if you actually want them to inherit the account, because that gives them the most access. Then they don't own it, so if they get sued, your money's still protected. And if you're just a signer, you don't inherit the account at death. So then that account has to go through probate. So you're either an owner, which means you get that account when someone dies, but it's also yours while you're alive. You're either a owner or a signer. Signer just means you can write checks. But when that person dies, your power just goes away. There's nothing else you can do. And you're not a signer anymore. And then POD we just talked about. So my favorite combo is you have your power of attorney that has access if you ever need them to, because if you're incapacitated, they would have access to the account. And then you've named beneficiaries on that account to inherit if you die. Make sense? Perfect. Signer's only while you're alive. So signer is just saying, I want Dolores to be able to write checks for me. But if Dolores gets sued, those creditors can't come after that bank account. So this is a side note. No one asked about this, but I like to tell people. And then we'll come back to beneficiary designations. Don't ever put your kids on your stuff. People are always like, I'm just going to put my kids on the house because then they'll get it when I die. Or I'm going to put my kids on the bank account because then they'll get it when I die. One, that's a gift, and it's a taxable event. Not necessarily meaning that you will pay taxes on it, but who wants to alert the IRS and give them red flags to audit you? Also, once someone is a joint owner, and this has happened so many times, Parents put their kids on the house, sometimes don't even tell them, but if they do, that house is now open to any creditor that child has. So if that child files bankruptcy, congratulations, you just lost your house. That child gets in an accident and kills somebody, congratulations, you just lost that house because they're getting sued. And your house would be part of that lawsuit. The big thing that happens unexpectedly is they own that house now and they can evict you. And I've seen it happen. 2 people who I sat in a room and said, don't put your kids on your house. And they're like, they're great. They would never do this. This is my Medicaid plan, so the government can't come and take my house later. A month later, she didn't have a house because her kid evicted her. Didn't use me as the attorney. Put the kid on the house. I can just say things. You don't have to listen to me, but I wish you would. So don't put your kids on your house. What's the point? Absolutely. So I think, yeah, transfer on death. So that brings me back to beneficiary designations. So thank you. So we said beneficiary designations are the most beneficiary designations are the most important estate planning tool. They override everything. So let's say you had Dolores as your beneficiary on your bank account, but then you do a will that says, you know what, not a big fan of Dolores. I want Holly to get everything. When you die, Holly doesn't get anything. The beneficiary always wins. So Dolores still gets that account. So homework today, double check all your beneficiary designations, bank accounts, life insurance policies, and any kind of retirement or investment account. IRAs, 401ks, an E-Trade account, they can all have beneficiaries. So make sure they are who you want them to be, but more importantly, that there's someone there. Because a lot of times banks don't even tell you that you can do that. And you can on every single account. That's a free estate plan. That avoids probate. It goes straight to that person on death. No questions asked. Yep. And you can have backups everywhere but banks because banks like to cause problems. All right. We're running out of time, so we're going to fly. Trusts. We had a lot of questions on trusts. Normally I would ask a bunch of questions for you, but we're going to get you out of here on time. Trusts are an entity that basically says, when you pass, who do you want in charge and where do you want your stuff to go? That sounds a lot like a will. So what's the difference? Basically, when you make a trust, you're creating an entity, and that entity can own property. And that's a really key distinction from a will, because a will can't own anything. It's just the instruction sheet for the judge to get through probate. A trust, think of as kind of like a business, and you name the CEO of that business, that's you, the trustee. And that trustee says or controls everything that trust owns. So what we do is we transfer all of your stuff into the trust, mainly your real property. So houses, land, and mineral interests. And then the trust becomes the beneficiary designation on all your other accounts, so it gets everything at death. That way you don't have to change a bunch of stuff while you're alive. Then when you pass away, the judge looks at you and says, do you need probate? And there's only 2 reasons, in Colorado anyway, that we go to probate. One is you own, does anyone know? One reason to go to probate?
No.
Yes. So if you have real property, specifically house, land, or minerals, you're in probate. It has to be in your name alone. And then the second reason is if you have over a certain dollar amount of assets, and this year that's $86,000. It changes every year. When I wrote that book, it was 60,000 or 66,000 or something like that. But it changes every year. You just have to pay attention to it. It's kind of my job. But if you don't meet either of those because your trust owns all of your stuff, the judge would look at you and say, Holly, what are you doing here? Do you own any real property? And the answer is no, because Holly's trust owns her house and her minerals and her land. And then they would say, okay, well, do you have over $86,000? And even if Holly's a billionaire, the answer is no, because the trust owns all her bank accounts and retirement accounts and life insurance policies. So on paper, it looks like Holly is flat broke, owns nothing. So the judge says, what are you doing here? There's nothing that needs to go through probate. See you later. Your trust keeps on living after you pass away, and you've named a successor trustee to kick in and do everything your trust said to do without needing court or a judge or an attorney at all. Yeah. So the question is, can you have a will and a trust? With every trust plan we do, we also do a will. And it's now called a pour over will. And that's because, let's say we do your plan perfectly and we get everything into your trust. And then 10 years go by and you forget you have a trust and you buy another house. And you forget to put it into your trust or buy it in the name of your trust. You now own a house in your name, not in the trust name, and then you die. That's going to have to go through probate even though you have a trust because you never got it into your trust. So that's the biggest problem we see with trusts is either your attorney didn't fund it for you, meaning they didn't transfer your house in there, which they should, or you bought more property and just didn't get it into the trust. So the will catches it and pours it into the trust anyway. So that's why we call it a pour over will. So yeah, you would do both. Yes. Yeah, great question. Joint ownership is a way to avoid probate. It's also a way that screws up estate plans a lot because people do a trust, don't transfer the house into it, and then they die and it goes to the joint when they wanted it to go to their kids. So you have to be very careful on how you own things because joint bank accounts, you've got a bank account with your daughter, but you've got 5 other kids and you want everyone to inherit equally, your daughter gets that bank account when you die, no matter what your plan says, because she was the joint owner on the account. So joint ownership overrides estate plans just like beneficiary designations do. And that's the other, do you have a question? So no, and that's a very specific deed. So that's how you avoid probate with a will, exactly what you're talking about. Does anyone know what that deed is called? Bingo. So a beneficiary deed is the transfer on death deed. So if you have a will and you don't have a beneficiary deed on your house, the house is going to go to probate. If you have a will and you have a beneficiary deed on the house, you can avoid probate with a will because that beneficiary deed transfers the house outside of the probate process. So it's how you put a beneficiary designation on your house. Yep, so that's why I say not everyone has to have a trust because if you put beneficiaries on everything, and you have a very simple plan, and you just have one house, you want to put a beneficiary deed on it, get it to the kids, that's perfect. We do that all the time. So people might say, like, why would you ever have a trust? So the con column for a trust, why not to have a trust, is really just one thing, to me anyway. People could disagree with this, but to me it's just more expensive. Our trusts are anywhere from $1,000 to $1,500 more expensive than a will. That's, for a lot of people, a pretty big con. However, the pro column of trusts is pretty full of stuff. So there's 3 main reasons, really like 5, but we always say if you own property outside of Colorado, a trust is a great thing to have because not all states allow beneficiary deeds. Colorado does, but if you own a house in Iowa, where I'm from, the only way to avoid probate is with a trust. Because you cannot put a beneficiary on a house in Iowa. And like half of the states are like that. Yeah. No, so the question is there a minimum asset value to create a trust? That's a very common question too. Like, I don't have enough assets to need an estate plan, let alone a trust. No, I just say these reasons I'm about to talk about are what qualifies you for a trust. Value of assets really have nothing to do with it. If you owned 50 houses in 50 states and you died with no plan, that's 50 probates we're going through. And on the cheap end, being $5,000 to $10,000 a pop, like, good luck. You're going to be in probate for a long time and spending a lot of money. A trust can pull all of that into your Colorado trust and avoid all 50 probates with one trust. That's pretty cool. So property outside of the state is a huge one. Minor children is a really big one, or if you want to leave to grandchildren who are minors can't inherit. So we're in that guardianship and conservatorship hearing if they inherit. So if you're leaving to a minor, a trust is almost, in my opinion, mandatory because we avoid court for that. It's a separate court process other than probate. Complex, yeah. So we'll do taxes really quick, and then I'll fly through the rest of these and probably just stay after for questions so we can wrap up and get people out of here that need to get going. But taxes, my long and short example on how estate planning benefits taxes or passing property at death in general, it has to do with basis. So basis is this made up term that the IRS came up with that basically just says, what'd you pay for your property? And so I like to have the silly example of, I bought my house for $1. And 100 years go by, and now it's worth $1 million. If I sell that house, the IRS is going to say, what'd you sell it for? And what's your basis? And what's the difference? Because we're going to tax the heck out of it. And that's capital gains tax. So there's $200,000 in that example that goes to the IRS. When you die, hopefully with an estate plan, but you can go through probate too, your kids or whoever's inheriting gets what's called a step up in basis. So in that example, their basis isn't $1, it's $1 million. So they can sell it the next day and pay 0 taxes. Trusts preserve that, and so do beneficiary deeds. So that's kind of the main tax thing. Colorado doesn't have an inheritance tax. We don't have an estate tax. Great place to die, woo! Also a great place to live. But so taxes aren't as big of an issue on passing away as people think they are, but there's still a lot of little things to think about. Like charities don't pay tax. So if you are going to get taxed on like a 401k, leave that to the charity and everything else to your kids, because then no one pays tax. So just little tips and tricks like that. Other than that, that's how trusts work. No one said they really wanted to dive into special needs trusts today, but there are hundreds of different kinds of trusts. Some of them are special needs trusts. That's how you leave to people who are on Medicaid. They should never inherit. Just like a minor should never be named as a beneficiary or inherit in your plan without a trust, an individual with intellectual and developmental disabilities should also not inherit directly. You should make a trust for them that inherits on their behalf. Because if you don't do that, they're going to get disqualified from their Medicaid benefits, and that hurts them, and you don't want that to happen. So their trust can inherit, and they get to keep their Medicaid benefits, and Medicaid's okay with that. We actually get it approved by Medicaid in advance. We've already kind of talked about guardianship and conservatorship. This is more so for people with special needs or adults who are incapacitated. Alzheimer's, dementia, car accident, coma, that kind of stuff. If you're still alive and you don't have powers of attorney, we're in a guardianship and conservatorship hearing for you. That's a living probate. That's not fun. That's where the court is appointing a professional to manage your stuff while you're still alive for the rest of your incapacity. I've seen that completely wipe people's estates out. That's not fun. I like to tell people to bounce their last check because that's the best estate plan. Don't do it because of this. Have powers of attorney to avoid all this stuff. But if you want to fall asleep tonight, there's some statutes up here where you can read like what the actual powers of guardians and conservators are. But it's basically look out for the best interests of the individual and make sure that they're taken care of. So hopefully you will get to avoid the court process by having a good estate plan. But if we are in any kind of court, this is guardianships and conservatorships specifically. When I was doing these, you would have sometimes an emergency hearing, which you can get in court like that day or the next day if someone's life is on the line. But normally it's about a month out. You have a court visitor come to your house to make sure the person that's getting appointed as guardian or conservator is a good fit. And then the court visitor is going to write a report for the judge. Then you have a hearing to decide if you can even be guardian or conservator for the person that's needing the help. That's all very expensive, and you're footing the bill for all of that without powers of attorney. Yeah. Depending on who it is. It could be a family member, but they could keep track of time and get paid as well. A professional is definitely getting paid. But once again, light at the end of the tunnel. Have an estate plan and stop all this. Yeah. Good question. So who keeps your original documents? You do, at our firm anyway. So we'd asked about, I think we covered almost all the questions, but this goes in with fees as well. So our process essentially is At the end, we have an initial consult, we have a planning meeting to make sure we got all the details together, we have a signing meeting, and at the end we have a family meeting. And I love that meeting because we get the whole family together. And I get to be, if you want me to be, the bad guy that says why this person's the number one person and why this person's number two. And it usually goes way better than anyone thinks it's going to. I'm usually not the bad guy. But if you need to blame me for anything, feel free. But that's where we talk about how the distribution's going to go and who's in charge and what their role is. And that's also when I give you your documents back. So your question was who keeps the originals? We would have to buy a lot of storage buildings to store all the original estate planning documents if we kept every single one. So I like you guys to have them. Plus, your kids may need them in an emergency, and they need to have access to them. You know, we have a lot of attorneys, so if I die, there's someone at our firm to back us up. But a lot of attorneys, it's just them. They're solo attorneys. So if they die and they have your plan, what happens to your plan? So we'd rather you guys have it. And then I wanted to touch on the fees question. Every attorney is different, so questions you should be asking your attorney. You don't have to work with us, but please work with an attorney. Most of us have free initial consultations anyway, so you can at least talk about it. But some do charge for initials, some do hourly rates. We do flat fees because we like you to know what you're paying up front. And we also try to customize packages for you. So all the documents we talk about come in that we talked about today, and most of the ones that are in my book, come in our packages so that you're protected in case anything happens, because we don't have a crystal ball. We don't know what's going to happen. So our plans try to keep you out of court in every scenario that could come up as best as we can. And those packages can range anywhere from $650 to upwards of $5,000. That's just us. Other attorneys are different. Some will be less expensive, some will be more. The closer you get to like downtown or Boulder, the prices tend to go up. But that's just a range to answer your question of what we do. A finance program? No, but we work with a pretty broad network of individuals that we trust, that we're happy to connect you with for like financial advising, accounting, insurance people. We've worked with good people and bad people, unfortunately, but we can point you in the right direction. But I will stop babbling. Congratulations, guys. You survived an hour with an attorney. Thanks for coming.